इज लिविंग राइट नाउ। ठीक है, बाजी से आपको खोल के किसी को बुलाइए यहाँ पर। अब प्रीति है ना यहाँ पर, आइए बैठिए, केस कॉल आउट।
From list, serial 37 from daily list. It's a restoration matter. 138 convict.
जस्ट मिनट, रणवीर जी को बुलाइए, कोर्ट में रहेंगे फाइल पकड़ाने के लिए। सुने आप, रणवीर जी को बुलाइए, कोर्ट में रहेंगे फाइल पकड़ाने के लिए। ये आप आए हैं? अच्छा, उनकी आप जाइए समीर जी। समीर जी आप जाइए, जस्ट लीव, कोई जरूरत नहीं कॉल करने का, आप जाइए।
Serial 37 from daily list for restoration. So 138 matter.
रेस्टोरेशन का क्या एजेंसी?
Of criminal revision.
कोई एजेंसी नहीं होता रेस्टोरेशन में।
From 37 serial is.
कोई बात नहीं, हो सकता है टेकअप हो ही जाए, कॉल करें।
मैडम सप्लीमेंट्री कॉल लिस्ट under the heading final disposal serial number WPS 5572 of 2016.
This I will dictate at a later time, 12:30. इसका डिक्टेशन 12:30 बजे। नेक्स्ट कॉल।
Under the heading water serial number 231 revision 769 of 2023.
Criminal revision number 769 of 23 with criminal revision number 89 of 23. The matter has been posted at the instance of the office, indicating that there is a typographical error in order dated 12/8/2024. In the third line of the same order, the date of the earlier order ought to have been 12/7/2024, and instead it has been typed as 12/6/2024. Peruse the records. In the aforesaid circumstances, the order dated 12/8/2024 is modified. The date mentioned in the third line of order dated 12/8/2024 is to be read as 12/7/2024 instead of 12/6/2024. On account of the aforesaid error, the time for compliance of the order dated, the time mentioned in order dated 12/8/2024 is extended till September 20. Also further status. वो प्रेम्पटी ऑर्डर था ना, तो इट विल नॉट टेक इट्स इफेक्ट, थोड़ा टाइम एक्सटेंड कर दी कोर्ट के एरर से नोबडी शुड सफर।
Now under the heading admission serial number 4 contains schedule 683 of 2024. Amrita Singh.
This petition.
Senior counsel is appearing online, your ladyship.
Where is the opposite party?
Regarding other
ट्रेन को 60 पास हुआ आज तो खाना हॉस्पिटल जाके अपना जाम में वापस से
A prayer for Passover has been made We will take it up at 12 o'clock. At 12.
Now serial number 5, content 7 to 9 of 2024.
The Director of Higher Education was supposed to comply the order on the ground of illegality committed by them, contrary to the recommendation of the university. We made the representations, my lord. Next, sir. 6,
When did you file your representation?
5th of March 24.
Did you file it within time?
My lord, as soon as we obtain the certified copy within the time, we will file.
Order is of 19. You apply on 28. You receive it on, it was notified on 27. Content civil 729 of 2024. Counsel for the petition is present. Nobody appears on behalf of opposite parties. Opposite party state. Counsel for the petitioner submits that the order dated 19th of February 2024 has not been complied. The petitioner has filed the representation contained in Annexure 6. Issue notice to the opposite party number
2.
2 for which requisite under speed post through the concerned police station. The requisite be filed before this court by next Friday. Counsel for the state is directed to seek instruction and file affidavit regarding service of notice. It line only. It will be open to the opposite party number 2 to engage an independent counsel for the purposes of the present case. Post this case on 4th of October. The affidavit regarding service of notice should be filed by 1st of
By the state. Affidavit.
by the state. Let this order be communicated to the Office of Learned Advocate for complaints.
Now we start from final disposal.
Sorry.
From final disposal of orders.
From final disposal पर देखते हैं आते हैं नहीं तो most of the time आते नहीं हैं कौन करें?
Daily published under the heading final disposal. Item number 1, essay 416 of 2016. Dr. Hasnan Varish.
Mr. Vance, yes, on the last occasion you were absent. Today, where is the respondent? Unnecessarily, this case is pending And notices were issued to respondent number 2 and 5.
In substitution matter, जी.
Respondent number 2 and 5.
2 and 5, yes, Mr. And one has filed a wakalatnama, therefore.
Yes, one has filed the wakalatnama, but service of notice upon respondent number 2 and 5 is not complete.
I have examined the file, my lords. It appears that it is complete. By simple process, it is complete.
Or by ordinary process, it is complete.
I have inspected previous.
Where is the respondent number 1? Second appeal can't be heard without both the parties being present.
And all the other respondents who is to be substituted are sister of the respondent and applicant. 2 brothers and 4 sisters. Father died below during pendency. Therefore, this son has executed wakalatnama. Therefore, we have filed the wakalatnama. And question of law has already been framed by your lordship, and I have already submitted the written document. And one or more time, this case has also been heard by your lordship.
Yes, we have heard it, I remember. Mr. Rajiv Kumar was appearing on behalf
Me
of the
not.
respondent at one point of time, and he said that the point of law has been wrongly formulated.
Yes.
That was his argument.
In the meantime, if your lordship will please, I have also filed IA for stay of the Taktabandi. If order may can be passed on that IA, then I will petition appellant will also be sure that no Taktabandi will be finally done.
Taktabandi has not been done so far.
Taktabandi report has been submitted by the Advocate Commissioner,
Okay.
and court below has passed order that it is confirmed.
So Taktabandi has been done.
Yes. I have filed second supplementary affidavit, my lords. That is on. It has been filed, my lords.
Mr. Varis, you have to take little more pain. Today they are not appearing. So if they do not appear, then we will decide it in their absence only. We can't do anything about it. On the last occasion, counsel for the respondent sought adjournment. And then let me just record that the service is complete.
My lords.
Because there is an office note that it is incomplete.
My lords.
Second appeal 416 of 2016. Dr. H. Varis, advocate, appears on behalf of the appellant. He submits that the service of notice is complete. The respondent number 1 has already appeared by filing wakalatnama, and the ordinary process service has been served upon respondent number 2 and 3 personally, 2, 3 and 5 personally, and so far as respondent number 4 is concerned, the same has been received by your sister. Considering the submissions, the service of notice upon respondent number 2 to 5 is taken as complete. Nobody appears on behalf of the respondents.
My lords, description of pro forma respondents 2 to 5 has been given in para 5 of
That's it, no
substitution.
problem, not important. There is a petition for substitution also, which is.
Yes, 1275. IA number 1275. So substitution may kindly be allowed,
Okay.
and the office
IA
may kindly
number
be directed
1272.
to paragraph 9 में description
1272 or
1275 में of 2000 1275 of 2020 में फाइल की थी। उसमें एक ऑर्डर पास हुआ था 6320 को।
या ये नहीं दिख रहा है
1275
6676 है।
वो तो ये है स्टे के लिए।
कहाँ है इसमें आइए से 127 Who has expired? The appellant.
Year appeal.
वकालतनामा सबका फाइल कर दिए?
ये वो तो प्रोफॉर्मा बनाया है ना हुजूर।
अच्छा अच्छा।
जिनको अपीलेंट बनाया है वो तो वकालतनामा दिए इसलिए उनको अपीलेंट बना दिए, लेकिन इनको चूंकि वकालतनामा नहीं एग्जीक्यूट किए इसलिए परफॉर्मा रिस्पॉन्ड किया। तो उनका डिस्क्रिप्शन है पैराग्राफ 9 में ऑफ माय
देखिए आइए नंबर 1275 of 2020. This petition has been filed seeking substitution of the deceased appellant number 1. Counsel for the appellant submits that the appellant number 1 has expired on
expired on
26/12/2019.
26/12/2019.
He submits that he has left behind him 2 sons and 4 daughters. The 4 daughters are already represented as pro forma respondent number 2 to 5. What about sons?
One son is the plaintiff and another is appellant number 1A.
The learned counsel submits that one of the son is plaintiff.
Yes, madam.
Who is
Respondent here?
respondent number
One.
Respondent number 1,
Yes, madam.
and the other son is to be
Appellant 1A.
substituted as appellant number 1 with bracket. After hearing the learned counsel for the appellant and considering the aforesaid facts and circumstances, IA number 1275 of 2020 is hereby allowed. The legal years of the appellant number 1 is already on record, except Idris Ansari.
ये क्या नाम उनका? इदरीस।
Idris Ansari. The learned counsel for the appellant is directed to make necessary correction, necessary amendment in the cost title in writing during the course of it. कर दीजिए इसको।
Respondent का भी परफॉर्मा respondent का
प्रोफॉर्मा रिस्पोंडेंट वाला तो प्रोफॉर्मा तो ऑलरेडी है.
इदरीस अंसारी एप्लीकेंट नंबर 1A हो गए.
बने
उसके बाद जितनी सिस्टर्स हैं
हाँ
उन लोग तो बकायदा हम एग्जीक्यूट नहीं किए, इसलिए दो उनको हम परफॉर्मा, तो परफॉर्मा रिस्पोंडेंट 2 उसको भी
वो तो ऑलरेडी है रिकॉर्ड पर ना. दे आर नॉट ऑन रिकॉर्ड. अभी आप बोले दे आर ऑलरेडी ऑन रिकॉर्ड.
They have already filed a petition long before.
That was never allowed.
सिस्टर्स कहाँ किए? सिस्टर्स नहीं किए.
प्रोफॉर्मा रिस्पोंडेंट बना के फिर तो उनको नोटिस करना होगा.
तो नोटिस तो ही गया, नोटिस तो ही गया. ऑर्डर डेटेड 6/3/2020 देखा जाए, और सर्विस इज कंप्लीट.
ठीक.
तो उनको सिर्फ कॉस्ट
उनको बना दीजिए आप.
कॉस्ट अटेंड
हाँ. Carry out the necessary amendments in the cost item.
ये
Merit तो pass हो गए. If it is not to be argued today, then थोड़ा सा हम भी आएंगे सीख लीव हमको बस से दूसरे के अगर करेंगे तो हम कर लेंगे. Because we had argued on the last occasion that the question of law which has been framed is not a substantial question of law, and that was he was supposed to reply whether it is a substantial question of law because it doesn't relate to the pleadings of the case. In the pleadings, nowhere it was the case before the London trial court or the appellate court that it's an occupancy reyes and it cannot be transferred. So therefore, completely a divergent stand coming out divorce of the pleading will not be a substantial question of law. There are a number of decisions on that point we have already argued on.
प्लेंटिफ का जो डिफेंडेंट जो है उन्होंने एविडेंस दिया DW2, उसमें उन्होंने साफ कहा
It is an occupancy right.
मिलॉट्स
He has said that it is an occupancy right.
नहीं, he has said that मैंने कोई हिब्बा नहीं किया है. अगर मैं हिब्बा करता तो इसको डॉक्यूमेंट बना के रजिस्टर्ड कर देता. साफ कहा.
वो अलग बात है ना. जब हम लोग सेकेंड अपील सुनेंगे तो क्वेश्चन ऑफ लॉ जो बना है उसी पे सुनेंगे, उसके बियॉन्ड तो नहीं सुनेंगे.
नहीं, तो वही
नहीं, क्वेश्चन ऑफ लॉ बना है.
क्वेश्चन ऑफ लॉ यही है.
Whether occupancy right can
Yes,
be
yes,
transferred through hiba.
हाँ, तो
His case is that it was nobody's case that it is an occupancy right. So therefore, this question does not arise for consideration in this fact situation.
but
This is what you said.
but so far as
Yes, Mr. Rajiv Kumar.
Yes, that had that been a pleading, the case would have been a different one. Otherwise also, so far as the Muslim law is concerned, Section 129 of the Transfer of Property Act and the catena of Supreme Court decisions which have been already referred to. Their case was before the trial court was that this hiba was not accepted, he has not come in possession. This was the defense. That was referred to by the.
Mr. Rajiv Kumar, you have argued the point that it is not a substantial question of law.
Yes.
But by deciding the entire case, we will take that also into note and then we will decide it. It can't be just, in order to say that it is not a substantial question of law, then also we have to go through the entire records, isn't it?
Naturally.
So therefore, we will ultimately decide the second appeal itself, keeping in mind your objection that this is not a substantial question of law. We'll keep it in mind.
First of all, I mean, it has to be decided when it will be heard
No,
on
we
this
will
question
not-
of law.
No, we will not deal it.
This is the
piecemeal.
law under section 100, subsection 5. This is the law which says that at the hearing of the appeal, the respondent shall be at liberty to say that the
Yes,
question
yes.
also
You
formulated.
have,
is not a
we have
question.
recorded you. We have
There are
recorded it.
There are two aspects.
We will not deal it
There
in.
are two aspects of the matter.
Two steps.
One is that the question of law is not the question of law.
That's
Second is, even if it is a question of law, then I have a right to argue on
That's
whether.
right. That's right. Therefore,
So there are two aspects of the matter. The only one aspect of the matter I have argued.
no, he has not yet argued his point. So the further question is, there will be a question of response from you once he has to argue the matter on merits, and then we will see. He will respond to your point also, that it is not a question of law, but he will have to, in totality, he has to respond to it. We will not deal it in piecemeal. Recently, I was looking at a judgment which says that even this aspect of the matter, whether it is a question of law or not, that has to be taken note of while disposing of the second appeal, if there is any objection to that effect. We'll deal with that also. So we have to deal with the second appeal in totality, and then if we find that it does not arise, then we will simply say that it is not a question
I
of
mean,
law.
in the question law itself, there is no indication how does it relate to any of the findings, because it has to essentially relate.
We will deal with it, Mr. Rajan. We will deal with it, but not in a piece. Don't expect a separate order on that it is not a question of law. We will deal with it and decide the second appeal as a whole.
So date fix it.
हाँ, date तो fix करना पड़ेगा.
In the meantime, my lords, execution of Takta Bandi may continue state.
कुछ नहीं होगा सर, अभी तक कुछ हो ही नहीं रहा है, तो क्या होने वाला है ये बताइए.
I mean, he is a son. He otherwise is entitled to a share. His share has been, if allocated, if he is granted a share, heaven is not going to fall.
आप बताइए, आपको 13 सितंबर सूट करेगा?
No problem.
ठीक.
I am ready to argue the case on any day.
13th of September, we will hear it at 2:50.
250.
And usually 2:15 में रहता था, हम तो effect suddenly हमको
सेकेंड हाफ में हम लोग का बेंच नहीं रहता है, इसीलिए
2:15 में तो
2:15 में ही पॉसिबल होगा उस दिन. इसके अलावा कोई और केस भी नहीं होगा.
My lords.
Now under the heading orders with defect, serial number 2 CMP 1024 of 2023.
Also, may kindly see IA number 478 of 2024. IA has been filed for ignoring the defect number 11 and 12 also.
What is defect number 11?
11 is the petition number, petitioner number 126 does not find place as connected file, and 12 is the petitioner of connected file is not party. May kindly see para 5 of my IA lords.
दोनों डिफेक्ट एक ही पर है.
एक ही में
CMP number 1024 of 2023, Counsel for the Petitioner submits that IA number 478 of 2024 has been filed for ignoring defect number 11 and 12 as pointed out by the office. He submits that the petitioners have moved this court in view of the fact that the original petitioner had expired on 8/4/2020 during the pendency of CMP number 626 of 2019. And therefore, the original petitioner of CMP number 626 of 2019 has not been made a party in the present proceedings. Considering the aforesaid submissions, IA number 478 of 24 is hereby allowed. The surviving defect in connection with defect number
other defects had already been removed.
defect number 11 and 12 is ignored for the present. Any private respondent?
Admission private respondent notice कर देते हैं.
Notice correct. क्या था ये
तो
petition?
restoration के लिए
क्या चीज का restoration?
restoration of WPC. WPC was dismissed to default on account of non-compliance. Thereafter,
State is not a party in WPC.
नहीं ठीक है. To Article 227 comment. The petitioner is a decree holder, Lord. File an application for effective delivery of possession, which was rejected, against which the petition was filed.
The aforesaid order has been passed only for the purposes of the present restoration application. Issue notice to opposite party number 129
Lords.
for which requisite for service of notice under ordinary process
Within 2 weeks, Lords.
be filed by next Friday.
Obliged.
Close this case on 4th of October, awaiting service report. रांची का ये ऐसा
सब रांची का है, Lords.
Now under the heading for orders, item number 3, 4, 5 and 6 wrongly listed. Now item number 7 CMP 1107 of 2023.
आइए nobody appears for the parties. IE number 11495 of 23 has been filed for ignoring the defect number 9.
Already password for few cases.
It appears that from perusal of the interlocutory application, it appears that the petitioner number 1 expired on 11/5/2021 and therefore in his place his legal heirs have been made party considering the aforesaid averment made in the interlocutory application IE number 11495 of 23 seeking ignoring with a prayer is hereby allowed. The defect number 9 is ignored for the present. Pose this case in the appropriate heading. Next week.
Next year.
Next Friday.
Now under the heading admission, serial number 8 CMP 189 of 2013.
इन दोनों का appearance record करना अपना appearance दे दीजिए दोनों जन क्योंकि आप लोग का nobody appears दिखाएगा.
Lordship, in this case, I file an IE number 7498. The opposite parties has been died, Lordship. Opposite party number 6. And thereafter, Lordship, opposite party number 11 and 13.
Six, 10, 11, 13, 17 and 20
Yes, Lordship.
have died.
Lordship.
So
They may be substituted, Lordship, there.
so where are the legal heirs?
They have given, a name has been given, Lordship. The first opposite party number, namely, has leaving behind following heirs, legal representative. So A, B and C. Thereafter, Lordship,
Just a moment. You have given the details of opposite party number 6.
yes. Then Lordship 10. Para 5, para 6. Details has been given, Lordship.
Statute of 1990
Yes.
कितना जनरेशन बदल
ये इसमें जो ये CMP फाइल हुआ है फॉर मॉडिफिकेशन ऑफ ऑर्डर लॉर्डशिप. There is a prayer for modification of order.
CMP number 189 of 2013 with IA number 7298 of 2020. The learned counsel for the petitioner submits that the interlocutory application has been filed for substitution of deceased opposite party number 6, 10, 11, 13, 17 and 23. So far as opposite party number 6 is concerned, his legal years are already on record and have been made opposite party number 7, 8 and 9. The details of legal years and representative of opposite party number 10, 11, 13, 23 have been mentioned in paragraph 5, 6, 7 and 9 respectively. So far as opposite party number 17 is concerned, his legal years are opposite party number 18, 19, 20 and 21. Issue notice to the opposite parties in CMP number 189 of 2013. Except opposite party numbers 6, 10, 11, 13, 17 and 23. So far as the aforesaid respondents are concerned, the notices we issued upon their legal years and successors, whose details have been mentioned in the interlocutory application. So 7, 8, 9 और कौन सा और 7, 8, 9, 18, 19, 20 and 21 को अलग से नहीं करना पड़ेगा आपको. बाकी जो लीगल ईयर्स एंड सक्सेसर्स है सबको नोटिस.
So let the office में make the party to the.
अभी कैसे पार्टी? पहले नोटिस होगा, they will come and then come.
Then this legal years also made party.
सारा को नोटिस करेंगे. In the main petition as well as interlocutory application. The requisite filed within 2 weeks.
Actually, may I submit one thing? If they had not been joined as a party, how would the notice?
The notice हम देते हैं before substitution.
Lodge.
And once they come, they'll come back with the वकालतनामा, then we will substitute. इसीलिए जो भी जिनका डेथ हो गया है, एक्सेप्ट वो कर दिए हैं, and then use क्योंकि ये फिर आपका बहुत दिन पेंडिंग रह जाएगा.
नहीं. Ordinary process.
Ordinary process. Post this case on 4th of October, awaiting service report.
We said we will also 3 weeks. बहुत सारा है, बहुत लोग हैं.
देखिए बहुत सिंपल है. अगर मान लीजिए 25 लोग आपके ऑपोजिट पार्टी हैं, जो डेथ हो गया उनको नोटिस
नहीं करना है.
जो जिनका डेथ नहीं हुआ उनका नोटिस फाइल कर दीजिए, और जिनका डेथ हो गया है उनके लीगल ईयर्स का.
वो तो जो आईए में है
ठीक है, 3 weeks हम टाइम देंगे,
3 weeks.
3 weeks. Then it will come on 18th of October.
Lordship.
Serial number 9, it is wrongly listed. Now serial number 10. Contempt civil for 745 of 2023.
Order has not been complied. Lordship comes to Lordship's order at page 10. Concluding part is Lordship to para 9, where the Lordships are considering all the aspect and the decision which they have taken a meeting to give to treat at par with the Secretariat cadre. In para 9, Lordship has passed in order to take a decision by the respondent number 2 in terms of all the decision which was the part and parcel of the writ application. Now, Lordship see the so cause filed on 4/1/23.
We have asked them to expedite the process of.
Yes, the time has also been framed by Lordship.
That's right. You see,
Yeah.
these kind of framing of rules is essentially a
I'm-
legislative function.
Yes, that what I'm saying, that Lordship is correct. But there must be a limit of the time. On 4/1/23, they file a so cause. And in para 12, they say it will take time. It's almost more than 1.5 years is there. What is the present status they have not stated. Whether they have taken action or not, what they have acted upon, they have not stated. They have reiterated what they have stated in the writ application. And simply in para 12, they have said they need a time. It will take time to frame the policy.
Yes, why don't you say that you don't want to frame the
Suppose has been filed in the month of January 2024.
You see, you can put a full stop to it by saying that you will not frame the rule and they have no right.
My loss.
We'll have nothing to say.
My loss.
But once you can't keep it hanging for an indefinite period of time.
They are giving the autonomy before framing of the rules, my lord, they have to give the autonomy to SIRD, my lord. For that purpose, they have initiated the process long back, my lord. And after passing of the order, my lord, they have sought the opinion of Cabinet Vigilance and Cabinet Secretariat and Vigilance Department of
We
Coordination.
understand this procedure. The
In
point
that
is,
procedure, my lord, they have returned back to take the sanction of the minister, my lord. In 24/11/2023, my lord. And in the month of January, we have filed the so-called. My
you
lords, may grant
update
some-
us. It can't remain pending
My
like
lords,
this.
that is.
You can take a decision that you don't want to do. There is no problem.
That's
You can take a decision. You can keep people hanging. That itself is violative of Article 21, isn't it? They should have some clarity in their life.
With respect to the rules, the 2010 rules are already there, my lords, with respect to the service conditions. Before framing, giving autonomy, then only their conditions will be.
Yeah,
framed.
autonomy is
Otherwise-
already, CRD is already an autonomous body. You cannot say that. It's way back, it is an autonomous body. And what they are doing, they are transferring the employees of CR to other department in other state. That's why they took a decision to treat at par with the secretariat. Now they have to take decision. Otherwise, they cannot transfer my service from one district to another state because it is an autonomous body situated in only in the state, Jharkhand in Ranchi only.
You can't have it both ways now.
Give some more time.
How much time do you need to update us?
Just 2 weeks, in 2 weeks I will update.
Content Civil 745 of 2023. Counsel for the parties are present. Counsel for the state prays for and is allowed time till 27th of September to file a supplementary show cause apprising the current status with respect to the compliance of the order passed by this court. Post on 4th October. Who is in serial number 11?
CRNP 995 of 2022. Mamta Kumar.
let's see, petitioner and respondent, both are husband wife. And earlier maintenance case was filed and in
No, we are not able to trace our file. Therefore, we have to just adjourn it. Serial number 11 आज नहीं, लेकिन ऑर्डर भी किस फाइल में ड्रॉ करेंगे? It will just remain pass over, right? It will be taken up by the next. इसको फाइल खुलवाइए भी, और अगर फाइल नहीं मिल रहा है तो रिकंस्ट्रक्ट करिए फाइल. The matter must be arising from the concerned court. Why a CRMP has been filed?
it's my mistake. But actual reason for filing this CRMP, maintenance amount was enhanced by this honorable court. And when I approached Bokaro Steel Plant and other places, they refused to stop this deduction of maintenance. And deduction was going on. That is why I filed the CRMP to stop the maintenance. I have paid.
CRMP to stop payment.
Yes.
What kind of a relief is that? When there is a direction passed by this court modifying the quantum of maintenance,
Yes.
then why a CRMP will be filed to stop the payment?
Divorce was granted, alimony was paid, so there was no reason to pay maintenance. Immediately, no one was ready to.
Permanent alimony was paid.
Permanent alimony, yes, that's it. It has been paid. 12 lakh rupees, it has been paid by the.
Show me some law that if the permanent alimony is paid, then maintenance is not paid. Because a divorced wife is also entitled for maintenance
Then
till she is married.
divorce has been granted.
Divorced wife under 125 is also entitled for maintenance. नहीं देखें.
लेकिन यदि एलिमोनी हो गया पेमेंट कर दिया।
Permanent alimony बोलते हो, मैं कहाँ है वो रिकॉर्ड पे लगाएं?
हाँ लगा है, इसमें है, ये ऑर्डर में भी आ चुका है।
Then the order has to be modified accordingly.
Yes.
Yes, what do you
यदि
say?
इसको थोड़े दिन के लिए यहाँ हमने वहाँ बोकारो डिस्ट्रिक्ट फैमिली कोर्ट में हमने एक एप्लीकेशन फाइल किया है कि इसको वहाँ से बंद कर दिया है और अब वो
वहीं से आप करा लीजिए.
हाँ तो थोड़ा इसको थोड़ा सा एक और डेट दे दिया है, नहीं तो ये फिर से मेंटेनेंस कटने लगेगा अकाउंट से। 9th of September को वहाँ पे डेट है
9 सितंबर को
जी, उसके बाद
तो 20 सितंबर को लगाते हैं.
जी
20 सितंबर को इसको प्रोग्रेस करें.
Madam, sorry, my answer. I am appearing on behalf of Selam. मेरा appearance record कर दीजिए.
आप अपना अभी कुछ भी नहीं रिकॉर्ड कर सकते, फाइल ही नहीं पता. There is some problem. We are tracing the file. Right? So we have to find out where is the file. If the file is lost, then you will have to reconstruct it. So there is no order is to withdrawn. We are just simply posting it on 20th of September. प्रोग्रेस में 20 सितंबर डाल देंगे और फाइल खुलवाइए और आप दोनों जरा अपना नाम दे देंगे फ़ोन नंबर के साथ. मान लीजिए फाइल नहीं ट्रेस होता है तो उसको जो भी आपने पिटीशन फाइल किया है उसका एक कॉपी हम लोग को प्रोवाइड रिकंस्ट्रक्ट कर देंगे.
Next, serial number 12, CMP 1036 of 2023.
What is the
This
same?
CMP has been filed for modification of the date of retirement of the petitioner matter in their order sheet file. Because initially the writ petition was filed, my lord, with the wrong entry in the prayer portion, and therefore we had filed an IA, that is annexure 1 of my CMP petition, my lord. My ladyship sees page 14 onwards. Page 18 is the relevant part. Here we have paid the respondent to pay the salary for the period of 31/12/2012 to 31/8/2017. Now these dates have been wrongly mentioned in the order sheet, my lord. So only correction to that part we are seeking modification.
This IA was allowed?
Yes, this IA was allowed by this order, my lord, annexure 2. Page 25.
So in the final order, it should be 31/8/12
31/12/2012
instead of 31/8.
to 31/8/2017. Date of retirement should be 31/8/2017, which has been mentioned as 31/8/2016.
You just point out the paragraphs where it has
Yes,
been.
Para 2 prayer has been quoted. That is wrong entry 31/12/2012. It should be to 31/8/2017. Third line of
The period from
31
रिकॉर्ड दिखाया
12
तो रीड का रिकॉर्ड में चेंज हुआ था.
नहीं वो कोविड टाइम में हुआ था तो चेंज नहीं हो पाया था कोविड टाइम में.
ये कौन बताएगा?
That was my mistake.
So, was there any direction to correct?
No, there was no direction. And Annexure 2 देख लिया जाए, इसमें करेक्शन ओनली था 31/12/2012 और इनका जो CMP भी है, IA एप्लीकेशन है, उसमें भी वही प्रेयर भी किया.
Retirement has been typed as 31/6, तो date of retirement को change करना.
हाँ date of retirement.
31/8/2012 की जगह 31/12/2012 करना.
जी,
यहाँ
और
पे तो 31/12/2012 भी लिखा हुआ है आपका
जी.
पैरा 1 में. तो इसमें
पेज
क्या
18 आइए का पेज 18 देखा जाना.
आईए का पेज 18 से क्या मतलब है आपका? आपका जो ऑर्डर हुआ आईए में हम लोग उससे मतलब रखेंगे ना.
ये लोग माय लीडरशिप मेरा डेट ऑफ बर्थ सुधार के 13/8/1957 किए, तो उससे अगर 60 इयर्स जोड़ते हैं तो 31/8/2017 होता है. और वो
नहीं, अगर आपने अपना प्लीडिंग्स ठीक से नहीं किया है तो इसमें कोर्ट का क्या गलती है? आपने कैलकुलेशन ठीक से नहीं किया है, प्लीडिंग ठीक से नहीं किया है, करेक्शन ठीक से नहीं किया है. हाउ आर वी रिस्पांसिबल फॉर दैट?
इम्प्यूग्ड ऑर्डर में वही है जो रिपीटिशन में लिखा हुआ है.
नहीं वो एक बार देखा जाए एनेक्सर 3 भी माय लीडरशिप.
एनेक्सर 2 में
31/12/2012 किया गया. डेट ऑफ रिटायरमेंट 31/1/2012 का जगह. और उसके
उनका
बाद
पैराग्राफ 1 और 4 भी देख लिया जाए, उसमें उतना ही प्रेयर किया तो उतना ही अलाउ भी किया.
नहीं पैरा 3 भी देखा जाए ना ऑफ आईए कि इसमें भी प्रेयर ऑफ द ओरिजिनल.
आईए जब आपका आईए अलाउ हो गया तो हम ऑर्डर देखेंगे ना कि आपका आईए देखेंगे. जब आपके आईए में एक ऑर्डर हो गया तो वी विल सी ओनली द आईए.
उसके बाद भी एक ऑर्डर हुआ है मतलब उसको देख लिया जाए एनेक्सर 3 को. इसमें करेक्ट सारा कुछ है पैरा सेकंड में कि wherein he is out to have retired on
एक
31.
सेकंड पहले एनेक्सर 2 में आइए.
Yes, ma'am.
ठीक है. एनेक्सर 2 में आईए नंबर 5946
जी.
राइट. उसमें आपने चेंज किया है ओनली 31/8/2012 होगा इंस्टेड ऑफ 31/12/2012.
जी.
ठीक है, मान लिए.
जी.
ओके.
जी.
उसके बाद
पैरा 2 ऑफ द नेक्स्ट पेज 26 उसमें आया है करेक्ट एंट्रीज जो है कि डेट ऑफ बर्थ एज 12/8/1957 31/8/2007 taking into consideration his date of birth as 12/8/1957 because they have themselves corrected my date of birth from 1/1/1953 to 12/8/1957. तो 1957 में 60 इयर्स जोड़ते हैं तो मतलब 2017 आता है. बस इतना ही.
इतना मॉडिफिकेशन में नहीं होता है. इट इज नॉट अ केस फॉर मॉडिफिकेशन. आपको रिव्यू फाइल करना पड़ेगा. इट इज नॉट अ केस फॉर मॉडिफिकेशन में छोटा मोटा कोई गलती का डेट का एरर कुछ ये सब एरर ये तो आप यू नीड टू चेंज. यू हैव टू चेंज द एंटायर ऑर्डर.
पूरा सब पैराग्राफ में वही लिखा हुआ है. And as per the pleading or in the repetition.
I received one thing.
The only thing I can take care of आपका submission तो we will not take care of at all because whatever is not mentioned in the repetition we don't bother about it. Secondly, maximum we can change your date of retirement as to 31/12/2012. 31/8/2012.
1957 से 60 इयर्स जोड़ते हैं तो
हमको इतना जोड़ तोड़ नहीं करना है ना. ऑर्डर पास हो चुका है. आप अपना रिव्यू फाइल करिए. सब में नहीं चलता. We can't do it.
लिबर्टी दे दिया जाए मतलब फाइल रिव्यू.
CMP number 1036 of 2023. Counsel for the parties are present. This petition has been filed for modification of order dated 19/7/2023 passed in WPS number 1297 of 2019. The learned counsel for the petitioner has submitted that there are discrepancy in connection with the mentioning of the date of retirement and the relief which has been granted to the petitioner by the order dated 19/7/2023. The learned counsel appearing on behalf of the opposite party has submitted that the order has been passed on the basis of averments made in the writ petition.
And as per Annexure 2.
And therefore it is not a case of simple modification of order. At best, the petitioner could have filed a review petition. And that's the same is also to be considered after referring to the materials available in the writ records. Right? Considering the opposite submission, this court is not inclined to modify the order dated 19/7/2023 passed in WPS number 1297 of 2019. However, liberty is reserved with the petitioner to file a review petition if so advised.
इसमें पहला पैराग्राफ में लिखा दिया गया कि जो रिलीफ है उसके लिए मॉडिफिकेशन है, सिर्फ ये करेक्शन ऑफ द डेट के लिए है।
रिलीफ उसका तो इम्पैक्ट तो रिलीफ पर भी
हाँ रिलीफ पे पड़ेगा,
डायरेक्ट रिलीफ पे पड़ेगा,
1 साल का घट जाएगा सर।
Serial number 13 CMP 1067 of 2023 Raj version.
Yes, petitioner. What is this?
We have filed CMP for restoration of the original writ petition matter, which was dismissed for non-compliance of the order passed by the Honorable Court in WPS number 3990 of 2020, 13/5/2022. That is for removing the defect. CMP order.
Where is the petitioner? CMP number 1067 of 2023. Nobody appears on behalf of the petitioner. Also, for the respondent is present. This petition has been filed for restoration of WPS number 3990 of 2020, which has been dismissed for default on 17/6/2022 for non-compliance of order dated 13/5/2022, whereby this court had granted preemptive time to remove the surviving defects. The averments made in the petition for restoration at paragraph 6 reveals that the counsel for the petitioner was suffering from burnout. Therefore, he could not remove the defect. After having gone through the petition seeking restoration, the CMP number 1067 of 2023 is hereby allowed, and the time for removal of defect as granted by the order dated 13/5/2022 to the extent it relates to WPS number 3990 of 2020 is hereby extended till 13 सितंबर 13 सितंबर नहीं 20 सितंबर पिटिशनर को खबर कर दीजिएगा मिस्टर राजवर्धन को प्रेम्प्टी ऑर्डर रह गया है, नहीं करेंगे तो वही कहानी फिर से हो जाएगी। सीएम प्लीज डिस्कस।
मसले में रिपोर्टिंग सीआरएम पे 3 to 1 को रूल करने को
Lordship seek permission to withdraw with liberty to file a fresh because Lordship during pendency one another 82 CRPC order has been passed and same has been executed.
Already we will not give we will just you just withdraw we do not we just do not क्या चीज़ का मॉडिफिकेशन आप फाइल करती हैं
82 order request for the Lordship with the direction to appear नहीं हो पाए थे due to COVID-19.
you just simply withdraw we will not CRMP number 3214 of 2023. Council for the petition seeks permission to withdraw this petition. Council for the opposite party has no objection to the prayer for withdrawal. Accordingly, this petition is dismissed as withdrawn. Prayer for करती आप नाम बताइए अपना मनीष कुमार अंडर इंस्ट्रक्शन ऑफ काउंसिल फॉर द petitioner मिस्टर कृष्णांश रे ठीक है एडवोकेट ऑनर साइन कर
serial number 15 CP 199 of 2024 Aishwarya Prakash
WPS
now बताइए क्या चीज़ का रेजोल्यूशन
Page 13.
क्या कारण है भाई ऐसा कोई ऑटोमेटिक रेस्टोरेशन थोड़ी होता है यस व्हाट इज द रीजन
22 तक डिफेक्ट नहीं बना
तो क्या किया क्यों नहीं कर पाए
एक तो बच गया था
एक भी रह जाए तो रह ही जाता है ना क्यों नहीं कर पाए रीजन बताइए
बाहर चले गए
हाँ लिखें इग्नोर भी कर दीजिए सब कुछ कर दीजिए फिर भी आप लोग डिफेक्ट नहीं रिमूव करते हैं क्यों प्रेयर करते हैं इग्नोर करने का नहीं करना चाहिए ना हाईकोर्ट में रेस्टोरेशन का कहानी नहीं खत्म होता CMP number 199 of 2020 Council for the parties are present. This petition has been filed for restoration of WPS number 2302 of 2023, which has been dismissed for default due to non-compliance of order dated 6/2/2023 in as much as the defect has not been removed. The learned counsel submits that the counsel for the petitioner had gone out of station and therefore the defects could not be removed. Considering the aforesaid submissions, the time to remove the defect, this petition is hereby allowed. WPS number 2302 of 23 is restored to its original file, and the time to remove the defect, which has been granted by order dated 6/2/2024, is extended till 20th of September. प्रेमली ऑर्डर आपका रह गया है, नहीं करिएगा तो फिर से ड्यूटी होगा.
Now serial number 16 CMP 241 of 2024 Siddharth Roy
for restoration of WPC number 837 of 2023 Lordship. So dismissed for non-compliance of the Lordship's order. Dated 5/7/2023. Reasons are stated in Lordship para 6 to 10 Your Lordship of application.
CLP number 241 of 2024. Counsel for the parties are present. This petition has been filed for restoration of WPC number 837 of 2022, which to dismiss for default on account of non-compliance of order dated 5/7/2023. Counsel for the petitioner submits that petitioner was not available and therefore he could not appear on that day. And in the meantime, the case has been dismissed for default. Considering the future submissions and being satisfied with the cause shown, WPC number 837 of 2022 is restored to its original file, and the time granted by the order dated 5/7/2023 it extended till 20th of September. CLP is accordingly dismissed.
Serial number 17, CMP 3 of 2024. Vishu Ranjan.
Lordship, this CMP has been filed for restoration of WPC number 388 of 23. It was dismissed for non-compliance of order dated 5/2/24. Lordship, we had already filed an essay on 9/2024, but due to 9/1/24.
So,
but the same was not corrected in the index. It was dismissed.
where are you stated?
Para 7.
CLP number 283 of 2024. Counsel for the parties are present. This petition has been filed for restoration of WPS number 388 of 2023, which stood dismissed on account of non-compliance of order dated 5/2/2024. The learned counsel has submitted that a supplementary affidavit was filed for removal of defect, but in spite of that, certain defects would not be removed. Considering the submissions, the WPS number 388 of 23 is restored to its original file, and the time granted by the time for removal of defect granted by the order dated 5/2/2024 in WPS number 388 of 2023 is extended till 20th of September.
Serial number 18, contempt second 345 of 2024. Anil Kumar Manzoor.
Order at page 89, which has not been complied. Relevant part is 10. Deputy Commissioner Palamu had to pass order.
Where is your representation?
And it's page 11,
the representation.
Yes.
We have not.
Sorry.
Time may be given also.
Counsel for the petition and the state address. The learning council for the state. Submits that a show cause will be filed by opposite party number 2. Show cause or compliance report. Considering the submission, post is placed on 20th of September 2024 and applying the learning council for the state to seek instructions from opposite party number 2 and file show cause/compliance report. The need will be done latest by 18th of September.
Serial number 19 contains saving report 31 of 2024. Abhishek.
Our order is not been complied with.
What was the order?
It is the NFK 1 page 13. Can we have a look at para 11 of the order? They have given a reason order. They have passed the reason order. May I read para 11?
No, they have given, they have passed a reason order.
They have taken a new cause of action, complete new cause of action, which has not been argued before the read court.
Need not be.
Which has not been
Where is
argued.
the reason order?
Reason order is by post they have given. It has not been filed for it.
You must have received it by now.
But they have given me WhatsApp. They have person filed. By now
File
they
it.
I haven't.
You file it. What reason order they have filed? Passed. You see, whatever may be the reason, once a reason order is passed, the order stands compliant. You have to challenge it.
Ballot,
You can't have it.
may I submit ballot? It is humble submission ballot. Ballot, I am submitting ballot. This is the reason order. May I? The new cause of action, such a belated state ballot, which has to be not argued before the red court. It has not came by the supplementary affidavit by the university. It has not been argued a single line.
Maybe.
Well, in the large belated state.
No. It
And
can,
it has
you,
came ballot
in fight by passing the reason order, you cannot say that they cannot take whatever stand has been taken in the counter affidavit. They cannot take any further stand.
But ballot, para 11 was the order passed by the honorable court ballot. It says ballot. May I read ballot para 11? When the respondent number 2 shall pass a reason order, keeping in light the judgment which has been relied upon the petitioner passed in WPS number 4162/2013, read with LPA number 22 of 2018, with LPA number 661/2019. My lord, reason order which has been passed, nowhere it has been discussed about this whole order which has been passed by the honorable court by lord. It is complete new cause of action they have related सच्ची बिलेटेड स्टेट कि पद पे जिस पद में वो गए थे वो पद खाली ही नहीं थी मैडम दिस इज द वे टू टेक रीजन ऑर्डर मैडम रीजन ऑर्डर एज फार एज माय अंडरस्टैंडिंग मैडम एंड पुटिंग क्वेश्चन टू मी मैडम रीजन ऑर्डर मींस अकॉर्डिंग विद लॉ मैडम इज इट लॉ इज a widow मैडम एज the reader has already been died in 2008 मैडम he was working from 2004 to 2008
of 2024. The learned counsel for the petition submits that a reason order has been passed, but in spite of specific reference having been made to order passed in WPS number 4162 of 2013/LPA number 22 of 2018 with LPA number 661 of 2019, the reason order does not refer to the same. copy of the recent order has been produced by the learned counsel for the petitioner, which is kept on record. Issue notice to opposite party number. You will seek instruction. Issue notice to opposite party number 2. Counsel for the state accepts notice on behalf of opposite party number 2 and submits that she shall seek instruction and file a show cause. Post this case on 20th of September 24. The show cause / compliance report will be filed by 18th of September. You consider it and pass a fresh one. You consider those judgments, say it is applicable, not applicable.
Serial number 20 contains civil 593 of 2024. Raj Kishore Sahu.
The order of this honorable court melody that annexure 1, page number 9. Not the operative portion of the order melody that page number 10, according to which Marot I was to file representation within 15 days from the date of the order. And after that, Marot, the Secretary Transport Department Marot was to pass Marot reasoned order. And if I am found entitled Marot necessary areas of salary as well as areas of pensions Marot was to be disbursed.
What happened? Not passed.
Not passed. Annexure 2 is my representation.
Counsel for the parties are placed. Counsel for the petition submits that order. Date is 19th of February 24, passed in WPS number 6630 of 23 has not been complied. Counsel for the. You will file your show cause?
No.
You will file your show cause? Issue notice to opposite party number 2. Counsel for the state accepts notice on behalf of opposite party number 2. Right or wrong?
I am appearing.
You will appear on behalf of opposite party number 2. Let this matter be posted on 20th of September 24. The show cause / compliance report will be filed by 18th of September.
Item number 21, CMP 707 of 2024.
Yes, petition.
This application has been filed for restoration.
Which case has been? Yes. Tell us. Why need to remove the defects?
मतलब डिफेक्ट एक ही था, टाइप कॉपी का डिफेक्ट था। मतलब पेज नंबर 28, 29, 30 और 31। 28 और 31 का मुझे ये फाइल किया, 29 और 30 मिस कर हम जिसके कारण डिसमिस हुए।
The learned counsel for the parties are present. This petition has been filed for restoration of WPS number 6175/23, which has been dismissed on account of non-compliance of order dated 30/4/2024, whereby time was granted to, whereby preemptory time was granted to remove the surviving defects. The learned counsel has referred to paragraph 5 of the petition to submit that on account of unforeseen circumstances the defects could not be removed. Considering the amendments made in the petition, particularly clarified the petition being WPS number and being satisfied with the cause shown, the petition being WPS number 6175/23 is restored to its original file, and the time for removal of defects as granted by the order dated 30 April 2024 in WPS number 6175 of 2023 is extended till 20th of September 2024. This CAP is accordingly disposed of.
Serial number 22, CMP 709 of 2024, Dalil Kumar Singh.
This is the restoration petition also. CMP has been filed for restoration of WPS number 698/123. There are some defects is regarding the correction in the petition. The reasons mentioned in the paragraph 5 and 6. And this has been additions for default by a common order dated the 17th May 2024.
It's not a common order. Every case is separately called. The order is common. Every case we have called separately. सब अलग अलग कॉल करके ऑर्डर किए, राइट? ऐसा नहीं हुआ।
करेक्शन है केवल।
जो भी करेक्शन है इसलिए कॉमन ऑर्डर मत, क्योंकि हर एक केस आई रिमेंबर आई हैव बीन कॉलिंग एवरी केस सेपरेट, giving an opportunity to the petitioner that if anything is to be ignored, that can be ignored. And I have ignored lot of defects. The common order का कहानी मत सुनो. This is not common. Reason बताइए.
Yes, ma'am. Para 5 and 6.
CMP number 709 of 2024. Counsel for the parties are raised. Counsel for the petitioner submits that his petition has been filed for restoration of the WPS number 6981 of 2023, which stood dismissed on account of non-compliance of order dated 17th of May 2024. Thereby preemptive time was granted to remove the supply. The learned counsel has referred to paragraph number 5 and 6 of the petition to submit that the reason for non-compliance of order is bona fide. Considering the government's made and being satisfied with the cost shown, WPS number 6981 of 2023 is hereby restored to its original file. The time for removal of defects granted by the order dated 17/5/2024 in WPS number 6981 of 2023 is extended till 20th of September 2024. The CAP is accordingly disposed. दोबारा TFD मत कर दीजिए, एक्सटेंड हुआ टाइम, फिर से प्रीएम्प्टिव ही रह गया. Yes.
Now pass over cases from the supplementary for list. Serial number 4 under the heading admission contempt 7683 of 2024.
Have you filed the show cause?
My lords, show cause is ready, I not filed, my lords. I was praying that it may be accepted.
What is this time?
My lords, we have filed an LPA, my lords, and so we were praying that this matter may be should adjourn and we will be kindly be allowed to pursue the LPA.
When did you file that?
The LPA was filed on. It was filed this week only, my lords. The date has not been stated, my lords.
I'm so sorry, because of connectivity problem, I could not address your lordship earlier.
No problem. They have filed a show cause during the court proceedings.
None served on us.
Just now
I'm not aware we have filed the KPA. So far as
They have filed an LPA. What is the date of filing?
The filing number is 8361/2024.
8361 of 24.
that's section 7,
They have filed a LPA.
Not sir, that NPA, we have filed a KVA, no notice has been served. And
They have
in
received.
that regard, can we have a look at para 14, possibly your lordships have signed?
I remember my order, but once they say that they have filed an LPA, we have to give them some time to get an interim order if they can. And since now you are aware that the LPA has been filed, they are already on caveat. Have you served them the copy?
I'll check my
No,
notes.
no,
Because the caveat needs to be registered, and once it is registered with against LPA.
On the last date also it was pointed out.
My lords. Then I'll serve, my lords. This was
You serve the petition during the course of the day.
I'll serve it during course of the day. I'll serve by both processes, hard copy as well as soft copy, my lords.
Just one thing I would like to point out, by my supplementary affidavit, they have, I have brought on record one notification 16.8.
I've seen it. For your information, for the information of the contemner, I must indicate that you see para 57, internal page 49, right?
Issue number D.
Issue number D and E, right? We have said that you are not justified in shifting and posting the petitioner in ex-cadre post and filling the 3 sanctioned posts by way of ad hoc officiating. In the supplementary affidavit, they have come up with notifications which says that you have again filled up with ad hoc arrangements. So this is something which is serious.
I'll respond to the supplementary affidavit as well.
No, there is no question. The point is that
Lords, it runs counter to para, your lordships finding in para 44, 45 and 46 of the
yes.
where your lordships have decried this.
And earlier also there are orders of this court that you are in a habit of filling up posts on ad hoc basis, right?
Definitely.
Which does not talk good about your officers. When and particularly when a person is available who can be, he's the only person who is available who can be posted, right? You shift him and you keep on making ad hoc arrangements. So this talks volumes about you.
Well, I was only paying that some.
I will give you time. They have already entered caveat. You serve them copy. And
with regard to this also, my lords, I may be granted some leverage, my lords, so that I can speak with the authorities and have the things.
So you know, by passing this order, by issuing certain notifications, again making ad hoc arrangement is absolutely in teeth of this.
My lords.
I don't know what interest you have in particular persons and how does the state function.
No, my lord, we cannot have any interest with anyone.
You can. It is apparent that definitely you have some interest in posting one person or the other.
Just grant me some time, my lords, to.
You see, a person is promoted to a post and you deprive him of all the benefits. He does not have any right to promotion, right? But you have already promoted him.
After promotion, if
you cannot deprive any person of his legal rights which flows from his promotion. And we have already held that his transfer or posting at the vigilance department was not in accordance with law. That we have already set aside. Now where has he to go? Will he be working? Now he is without a posting.
Without a posting. Technically he is without a posting.
So you keep him without a posting?
No, he cannot. Just give me some time, my lords, to.
You apprise your, who is the contemner
Chief
here?
Secretary himself.
Chief Secretary, and also by supplementary affidavit, I have brought on record that personal,
Yes.
If the lordships will turn to running base of your lordships here.
Yes.
Suffice is to say that the order has not considered the point of equivalence properly and accordingly cannot be sustained at all. Is that the fact? To be open to the respondent to take fresh decisions on the point if such occasion arises.
That's right.
The issue of occasion would arise if they decided to favor of the respondent upon challenge to this done.
Yes.
Your lordships have not missed word in view of the facts and circumstances. And then there was kindly see three more paragraphs. Paragraph 54, 55 and 56 of the done.
You see, we have said that you lack in fairness.
Malus,
And you repeat the same thing.
They have time enough.
The words are,
Malus.
very serious.
At present, arbitrary and justified malus, I get the point malus.
And further I say, it does not show fairness on the
Fairness,
part of the
malus.
state. And you perpetuate your unfair activities.
Such matters, I don't know.
What personal grudge can the state have against any person?
It cannot and it should not malus.
Then
Or just grant me some time malus, so that
this person
definitely
is the only person
Only
in the
senior
entire state
malus.
who
It
is
is senior
holding, who has been promoted to such a post, right? It is something like, you are being you are being promoted to the post of principal,
And
but somebody
not
else
allowed-
is the
not
in
allowed
charge
to work,
principal.
not allowed to
But
work,
somebody else is the
shifted
in charge
some
principal,
other
and he
person.
will continue with that.
Shifted
Permissible
just
and
to
law.
a malus. I get the one malus. Just some accommodation malus. Let me have a
We'll post it every week.
malus.
And you apprise us about your progress. We do not know.
Definitely
Because it's an urgent matter.
Definitely malus.
You by your conduct,
Malus.
if you deprive this person of his rights flowing from this judgment, and if judgment is not set aside, then we will certainly put you.
Definitely malus. I go down to that. I cannot have anything to say.
Even if he retires, we'll book you for that. You cannot deprive a person of the bench. You just go and get a stay order.
Definitely.
Everything will be okay. We don't have any personal grudge against anybody, isn't it? But you can't behave in this manner.
Definitely malus.
Every day is important for a person who has been promoted to the highest post in the cabinet. Two things you have done. Earlier you have deprived him by posting somewhere else, shifting, wherein we have held that it is not fair on your part. And now you have again made ad hoc arrangements. And this person is left without posting. Tell your officer,
Malus,
right?
I'll communicate it in the most possible manner, malus, and I'll
No,
try
you ask him to see the YouTube.
Definitely. And I'll also
You ask
try
him to see the YouTube. Ask him to see the YouTube.
Definitely.
It is there in the YouTube.
Yes,
What's
yes.
the problem about it? He
No,
will
no,
have his first-hand information about what the court has said.
Definitely. But I was only playing the malus that some
Every next week it will come.
Only-
You just expedite, you just
Definitely.
remove your defects, serve copies on
I'll
home.
do it today itself, not an issue malus. I'll do
Because as on date, there is no stay order.
malus. I'll go down to that.
Like you have transfer order, comply and challenge. You comply and challenge. What's the big deal about it?
Subject to, in many cases, we have passed employers
Yes.
subject to outcome of the
Yes.
appeal. Definitely.
That's right, Manoj. Subject to the result of the challenge.
Yes. You comply and challenge.
May I,
Nobody cares. You see, there are so many issues decided.
malus,
So therefore, it is good that you have filed an appeal. Right? Things should be set at rest.
definitely, malus, the list should at least come to alpha.
Yes.
And identification.
So therefore, you go ahead with that. But you cannot deprive the petitioner.
Malus,
of
only
the
I was seeking for one extra week's leverage this week only. Only this week.
I took almost 3 months to decide it.
Malus, I got on to that. Well, I was only
That too in a case of transfer. Unheard of. The court would take 3 months to decide a case like this.
because I was only paying for an extra week's leverage malus. So
I'm just posting it next week.
an extra week malus. Only for the
No.
purpose malus, just of the record if I may submit malus. So Monday we are having a holiday malus. just one extra week so that I can also convince.
No, you just tell us every week.
Definitely.
As to what is happening to your LP.
My lords. And also with regard to the other ventures, my lords.
Content Civil 683 of 2024. Where is your showcase?
Plus one more paragraph which I wanted to show to my lord. Plus the posting and notification on this board. If your lordships will look at para 8 and 9 of my affidavit supplementary. Plus it's done by the principal secretary. Recommendation book. Chief Secretary would approval improving the one of the 24. Because the principal secretary was served a copy of the order, he was respondent number 2 in the list. Because even the reminder was served on the principal secretary, notwithstanding that, possibly not, apart from the direction being specific to the chief secretary, he has not committed a willful disobedience and contempt. Currently, there are 8 and 9 of 5.
We'll take care of that. Content Civil 683 of 2020. Counsel for the parties are present. A show cause has been filed on behalf of opposite party number 2 during the court proceedings which is taken on the learned additional advocate general Mr. Ashutosh Anand submits that one LP has been filed against the order involved in the present case, being filing number 8361 of 2024, and he prays for some time. The learned counsel for the petitioner submits that she has entered a caveat. Counsel for the opposite party undertakes to serve copy of the letters patent appeal to the learned counsel for the petitioner during the course of the day. The learned counsel for the state submits that he will take expeditious steps. He will take steps for expeditious disposal of the LP. Post this case on next Friday. The council should apprise this rule as to whether the appeal, no, that should be sufficient. That's all.
Delhi Congress, serial number 23, content civil 717 of 2024. Swabha Arun.
Annexure 9 is the order lordship order has not been complied. Lordship may see the para 2 first. There is a threefold prayer of the petitioner. Para 2 lordship. Twofold prayer. First, A and B has not been complied till date. So far the B is concerned, which I have stated in my petition also. Out of 15 lakh, only 10 lakh has been given. And rest, they have not passed any order. As per the Lordship's direction from page, Lordship paragraph 9 or 9 onwards.
Your final show cause?
They have not.
The respondent number 3 was given a direction, which is the university, whereas I am appearing for the state.
Where is the learned counsel for the university? Konan University. You will accept notice on behalf of opposite party. You will accept notice on behalf of opposite party. Your name? Ayushi, give your appearance. Your junior counsel to Mr. Dr. Okay, contempt civil 717 of 2024. This petition has been filed for deliberate and bringing to the notice of this court deliberate and intentional violation of order dated 7/5/2024 passed in WPS number 5760 of 2023. Issue notice to opposite party number 2. MS Certain Sir, Junior Counsel to Mr. APC, Advocate, who appears on behalf of Kolhan University, accepts notice on behalf of opposite party number 2 and undertakes to file show cause/compliance report. Post this case on 20th of September 2024, the show cause/compliance report will be filed by 18th of September.
Serial number 24 CRMP 995 of 2024 on Parker.
This petition.
Petition was dismissed on 7/3/2024 for non-compliance of the Honorable Court Order dated 17/2/2020.
What is the reason?
Reason because defect has not been removed. Limitation petition was not filed in time on this. Because petition was not in my contact and he failed to contact me within time, hence limitation petition was not filed.
CRMP number 995 of 2024. This petition has been filed for restoration of criminal revision number 1352 of 2022, which stood dismissed on account of non-compliance of order dated 17/2/2024. The learned counsel submits that only the limitation petition was to be filed and on account of personal reasons.
Two other defects
The petitioner was, sorry?
Two other defects are also.
The line हटा दीजिए. The learned counsel for the petitioner submits that due to some personal reasons, the petitioner was outside his house and failed to contact his lawyer, on account of which the defect could not be removed. After hearing the learned counsel for the, आप हैं स्टेट की तरफ से, counsel for the parties are present. Being satisfied with the cause shown, the criminal revision number 1352 of 23 is restored to its original file, and time for removal of defect granted by the order dated 17th February 2024 in criminal revision number 1352 of 2022 is extended till 20th of September 2024. This CRMP is disposed of as a post.
Madam, petition serial number 25 is also missing. Yes, I should have filed.
So missing files also? अगला फॉलो.
Now serial number 26 CRMP 1018 of 2024 Manoj Machowar.
Yes, petition.
It was dismissed due to non-compliance of ordinance.
Good job.
The reason has been given in paragraph 5 for not surrender in time.
That was only defect.
There are two defects with respect to one filing of certified copy and one with respect to surrender certificate. So for filing of certified copy, I have received the certified copy. Just after restoration, I will file. And thereafter.
आपका ये प्रेमली टाइम एक्सटेंड कर देंगे बस. आप सरेंडर सर्टिफिकेट भी फाइल करिए और सब आप CRMP number 1018 of 2024. Counsel for the parties are present. This petition has been filed for restoration of criminal revision number 526 of 2022, which stood for non-compliance of the entry order dated 17th of February 2024 regarding removal of defects. Counsel for the petition has referred to paragraph 5 of the petition and submits that the reason for non-compliance of order of this court is bona fide. After going through the evidence made in paragraph 5 and being satisfied with the cause shown, CA criminal revision number 526 of 22 is restored to its original file, and the time for removal of defect granted by the order dated 17th of February 2024 with criminal revision number 526 of 2024 is extended till 20th of September 24. CRMP number 1018 of 24 is accordingly disposed of in their results.
Serial number 27 BA 1187 of 2024, Amit Kumar.
Yeah, by your counter.
The study has been provided to me, the necessary instructions with respect to arrest of the absconder police, that is yet to be received.
That instruction has already been received.
And as regards criminal activity, there is no antecedent in the Murgu PS.
You should give the antecedent in the entire state.
They are yet to send this.
Are you serious? What do you want? In NDPS case, bail should be granted. When we talk about criminal antecedent, you have to take it for the entire state. You have filed your counter?
No.
Why have you not filed your counter?
Because the necessary instructions are yet to be.
Who has to give you that instruction? Who has to give you that instruction? Tell us.
Ask the concerned SP as well as to the concerned PS.
So he should come. You tell us.
Only
Who is the
one-
person? Who is
only
the person
one-
who is not listening to you?
Only one.
You see, your non-compliance gives a leverage to the petitioner to seek bail. In an NDPS case,
Only one indulgence.
BA number 1187 of 2024, nobody appears on behalf of the petitioner. The order passed by this court has not yet been complied by the state. Post this case on 6th of September. The affidavit of the state should be filed latest by 4th of September. Case diary में क्या?
Case diary में क्या? But
The-
it is
the
earlier
council-
rejected.
Sorry?
Earlier files rejected.
Maybe rejected. Give me the case diary. You'll give me the case
I
diary.
will get a copy, photocopy.
The counsel for the state is directed to submit the case diary before this court.
Within a week, I will.
Much prior to the next date.
Serial number 28 CRMP 1322 of 2024, Manoj Mansa.
The restoration of criminal revision. My lord was granted community time to remove all the defects till 7/3/2024. All the defects removed except the petitioner's surrender certificate. Petitioner surrender within time, priority time, on 5/3/2024. Surrender certificate could not obtain till 7/3/2024. But surrender before.
That was the only defect.
All
Party
defects.
sir, have been removed. You have filed your surrender
Surrender
certificate?
certificate.
No. Here you have filed it. इसका original कहाँ है? Certified copy. You file it in CR criminal revision. You have the certified copy.
I have filed.
सर्टिफाइड कॉपी आपको क्रिमिनल रिवीजन में फाइल करना पड़ेगा. आप किसमें फाइल करती हैं? You have already filed it in the criminal revision. Where is the certified copy? We don't have the certified copy here. है ना आपके पास? हम आपको एक्सटेंड कर देते हैं. आप क्रिमिनल रिविजन में फाइल कर दीजिए. ठीक है? देखिए CRMP number 1322 of 2024. This petition has been filed for restoration of criminal revision number 1277 of 2022, which stood dismissed on account of non-compliance of preemptory order dated 23/2/2024. The learned counsel for the petitioner submits that the only surviving defect was in connection with filing of surrender certificate. He submits that the petitioner had surrendered within time, but the same could not be filed in the criminal revision, and therefore the case has been dismissed for default. He has annexed a copy of the surrender certificate along with this petition, and he is in possession of the certified copy. Considering therefore his submission and being satisfied with the cause shown, the criminal revision number 1277 of 2022 is restored to its original file, and the time for removal of defect granted by the order dated 23/2/2024 is extended till next Friday. कर देते हैं, है ना? अगला तो जेल में है, till next Friday. This revision, this CRMP is accordingly disposed of.
Serial number 29, CRMP 1325 of 2024.
This petition.
One of this application has become infructuous as the petitioner has done.
CRMP number 1325 of 24. The learned counsel for the petitioner, Mr. Shivam Sahai.
I'm appearing on behalf of Mr. Shivam Sahai.
On instruction of Mr. Shivam Sahai, advocate on record, submits that he does not want to press this petition as it has become infructuous. This petition is dismissed as not pressed. Complete. What is your name?
Siddharth Jain.
Siddharth Jain. इनका appearance record करें.
Serial number 30, CRMP 1443 of 2024, Mohammed Sajid Gunias.
For restoration of the criminal provision 1589 of the which was dismissed for non-compliance of the court's order, and this one was dismissed on charge 4/2024. But may not matter between them. The petitioner and opposite party have been pacified, and prior to 1 and 2 days of dismissal, 2 IAs has been filed. One in the form of joint compromise, and one for on this exemption from surrender.
NI Act.
NI, which I have depicted my case.
But ultimately the same could not be placed before the
Placed.
court.
That is.
Because CRMP number 1443 of 2024, counsel for the petitioner submits that this petition has been filed for restoration of criminal revision number 1589 of 2019, which has been dismissed for non-compliance of order dated 14/2/2024, wherein preemptive time was granted to remove the surviving defects. The learned counsel submits that just 2 days prior to expiry of the prescribed period, a joint compromise petition and a petition seeking exemption from surrender was filed. The matter arises out of conviction for offence under section 138 of Neglected Instruments Act. The learned counsel submits that the 2 interlocutory applications should not be pressed, and therefore the revision has been dismissed. Considering the aforesaid submission and being satisfied with the cause shown by the petitioner, criminal revision number 1589 of 2019 is restored to its original file, and the order dated 14th of March 2024 is extended till 20th of September 2024. 14th of March 2024, passed in criminal revision number 1589 of 2019 is extended till 20th of September 2024. It further appears that two interlocutory application has been filed in the criminal revision application. It will be open to the petitioner to mention this case prior to 20th of September 2024 so that the interlocutory applications can be considered. Other side को लेके आइएगा नहीं तो ये ऐसा ही order रह जाएगा. इतने आप लोग नेग्लिजेंट हैं कि कुछ कहने का नहीं.
Ma'am, one passover case at 12:30. Now for the supplementary call this passover case fine under the heading final disposal. Serial number 1.
कोई और डिफेक्ट नहीं है ना, देख लेंगे. डिफेक्टिव पिटीशन में हम कोई ऑर्डर नहीं करेंगे. आप अपना फाइल चेक कर लीजिए.
Serial number 1 WPS 5572/2016. दिवाकर उपाध्याय.
WPS number 5572 of 2016. Auditor and counsel for the parties. This petition has been filed for the following review. The legal counsel for the petitioners by the soft copy भी आया हुआ है. The learned counsel for the petitioner submits that the petitioners are primarily aggrieved by the fact that the respondent state did not take steps for recommendation of the name of the petitioners for presidential police medal for gallantry within that PPMG. Along with other persons who were identically placed on account of which the said award would not be conferred upon the petitioners. The learned counsel submits that the presidential police medal for gallantry is not just a medal, but huge prestige is attached to the same, which also entitles the persons who are conferred with such medal to have out of turn promotion in terms of rule 660 within that 660C of the police manual. And therefore, the petitioners are highly prejudiced by the conduct of the state. While giving the background of the case, the learned counsel submits that on 5/12/2003, a bold encounter took place in the district of Bokaro, whereby a small police team, including the petitioners, took on a huge contingent of 150 to 200 heavily armed Naxalites, and one top Naxalite was killed, and huge arms and ammunitions and cash was recovered. In the incident, unfortunately, one police constable lost his life, and 5 police personnel, including some of the petitioners received gunshot injuries. In the year 2004, the then SP Hazaribagh recommended the name of 13 persons, including the petitioners, for presidential medal to the DIG Hazaribagh, who in turn forwarded the same, who in turn agreed with the recommendation and forwarded the same to DIG Police Headquarters at Kanpur. And then it was eventually forwarded to the Home Secretary Government of Jharkhand. The Home Department Government of Jharkhand released an office order whereby out of 13 persons, 9 persons, including the petitioners, were granted Jharkhand Chief Ministerial Medal, and the petitioner's name was not recommended for the presidential medal. Being aggrieved, the petitioners made representation. वो 9 लोगों को मिल गया था ना, जिनका नाम क्या था? चार. The Learned Council submits that the 4 persons whose names were recommended for presidential medal were already granted the medal by the Honorable President, but the petitioners were left out. Being aggrieved, the petitioners made representation on 1/1/2006. It was considered after expiry of 5 years on 22/6/2011, and a second recommendation was made wherein the name of 5 persons were sent for the presidential medal. Again, the petitioners were not considered. The petitioner number 1 filed a writ petition before this court, being WPS number 536 of 2013. For consideration of this case for presidential medal. And during the pendency of the writ petition, he came to know that his name has again been recommended, and consequently he withdrew the writ petition. The Undersecretary Government of India issued a letter to the Home Secretary Government of Jharkhand dated 21/10/2013 for furnishing the representation of individuals and separate proposal on prescribed pro forma for the award of presidential medal to the petitioner number 1. And further, his integrity certificate was also called for by letter dated 5/3/2014. And before the name of the petitioner number 1 could be considered, the SP Hazaribagh forwarded fresh recommendation for grant of presidential award for the remaining 7 persons, including petitioner number 1 and the other petitioners of this case. The Undersecretary Government of Government of India issued a letter dated 15/4/2015 seeking an explanation from the Home Secretary Government of Jharkhand as to why and under what circumstances there was a change in view after 10 years, and for recommendation of the remaining 7 police personnel for award of presidential medal. The state government was further directed to furnish the said reply along with magisterial inquiry report of the incident dated 5/12/2023. A response was sent by the IG within bracket Human Rights Jharkhand by letter dated 31/7/2015 that at the relevant point of time the magisterial inquiry was not done as at that point of time the magisterial inquiry was not required to be conducted. In response, the Undersecretary Government of India issued letter dated 4/9/2015 asking the Home Secretary Government of Jharkhand to conduct the magisterial inquiry of the incident and furnish a copy of the same for further processing of the proposal. And ultimately, the magisterial inquiry report was forwarded by letter dated 26/11/2015. And integrity certificates were also forwarded by letter dated 11/1/2016. The Learned Council has submitted that ultimately on 8/2/2016, the Undersecretary Government of India sent a letter to the Home Secretary Government of Jharkhand stating therein that the proposal of the petitioners for grant of PPMD after careful consideration has not been approved and thereby it has been rejected. The Learned Council submits that the petitioners were a part of the same operation which had taken place on 5/12/2003, and the documents on record reveal that the petitioners' participation stood on same footing as that of those persons who were already granted presidential medal pursuant to the earlier recommendation, and therefore the only reason for rejection of the claim of the petitioner, for non-consideration of the claim of the petitioner for presidential medal was delay on the part of the state. The Learned Council submits that such delay has caused irreparable loss and injury to the petitioner, not only in terms of promotional avenues but also in terms of prestige involved with the risk, the prestige involved and recognition with respect to the risk they had undertaken to encounter the hardened Naxalite. And therefore, the petitioners at this stage are only seeking compensation. Correct? The Learned Council appearing on behalf of the state has submitted that a supplementary counter affidavit has been filed in the present case dated
28.
2024, wherein it has been mentioned that it is not clear from the records. The records are not available to explain as to why the names of the petitioners were not recommended at the relevant point of time. Correct? देख के बताइए.
Also, they have stated that it is difficult to ascertain in paragraph.
In paragraph 6 of the affidavit, it has been stated that it is difficult to ascertain and determine as to why the name of the writ petitioners were not recommended by the state government for the Police Medal for Gallantry Award. As 19 years have already elapsed, however, it has been submitted that the petitioners have been suitably awarded by the prestigious Jharkhand Chief Minister Bravery Award for the same gallant action. It has been also mentioned that so far as petition number 1 is concerned, the Bravery Award was issued by memo number 426 dated 13/11/2001 and has also been given advance increment and cash award of ₹7,000 along with the medal.
Further in para 9.
The Learned Council has further referred to para 9 of the counter affidavit to submit that awarding a medal by state government and government of India is an honor, and there is no legal right on any police personnel whose name have been recommended, and there is no such provision for grant of compensation in such cases where the medal is not conferred. The Learned Council has also submitted that there are numerous instances where the recommendation has been made, but the medal has not been ultimately conferred. The Learned Council has further submitted that not all recommendations are accepted by Government of India due to scrutiny at various levels, which are based on intelligence and other confidential reports. But certainly the same would not reflect in the order declining to give the award. The Learned Council at the same time submits that he is not aware as to what transpired at the level of Union of India for ultimately not granting the award. Not granting and rejecting में थोड़ा सा फर्क है. Not granting the award, the presidential award. He submits that the same was certainly considered in view of the fact that petitioner number 1 had filed a writ petition and pursuant to which his matter was considered, and while his matter was considered, the case of other persons were also considered.
And magisterial report was.
And the required magisterial report, which was called for by the Union of India, was already sent.
One more thing I would like to point out, Your Lordship, in Annexure 8 of the writ petition, it is not the case that the persons who have been granted presidential medal out of the recommendations which were done, in para 3 it has been categorically held by the Union of India that initially those names which were recommended, their names were also rejected. And later on they have been granted presidential medal.
Initially their name was also.
Yes, Your Lordship, may come to page number 68. Annexure 8 of the writ petition. Para 3, if I may be allowed to read.
Yes.
As regards to Sarchu Police Station case number 11 of 2003, dated 6/12/2003. It is intimated that earlier state government of Jharkhand, by letter dated 19/11/2005, had sent a proposal for award of PPMG to Shri Anurag Gupta SP, Hemant Popor DSP, Arun Kumar Dubey Inspector, and Naresh Prasad SI for the action dated 5/12/2003. This proposal was rejected by CPAC, who is the competent authority of Union of India. It was intimated by the state government of Jharkhand, that 9 other personals who had participated in the operation were recommended for award of Chief Minister Medal for gallantry on the occasion of Jharkhand Raising Day, that is 15th November. Thereafter, in the next page, State Government of Jharkhand, by letter dated 7 June 2012, had requested for reconsideration of the case for award of gallantry medal in respect of above 4 police officers personnel, including one addition recommended.
The Learned Council has referred to the letter dated 21st of October 2013 issued by the Government of India, Ministry of Home Affairs, in particular paragraph 3 and 4, to submit that initially the name of 4 persons were recommended who were involved in the same gallantry action, and the Union of India had initially declined to grant the award, but subsequently they were informed that these persons, that the persons, and subsequently it was considered afresh, and the names of, and 5 persons were granted the award, including 1 person who had died during the operation. Paragraph 3 and 4 of the said letter is quoted. The Learned Council, appearing on behalf of the Union of India, has submitted that a counter affidavit has been filed on their behalf, and it has been mentioned therein that the case of the petitioners was considered in meeting. ये CPAC क्या है? By the competent authority. आप लोग ना अपने काउंटर एफिडेविट में बहुत ज़्यादा
Central Police Award Committee.
Central Police Award Committee, but who considered the citations, but did not recommend the present petitioners for the award. The Learned Council submits that the case, their claim was considered, but no recommendation was made. After hearing the Learned Council for the
Your Lordship, kindly see the order dated annexure aim of my counter affidavit 18th February 2016. Your Lordship, the last line, you say that the above proposal was considered carefully in this ministry.
The Learned Council has referred to the communication of the Government of India to the Principal Secretary, Home Department, dated 19th of February 2016, and submits that their matter was carefully considered in the ministry and then it was regretted. The Learned Council submits that no further reason was required to be assigned. No reason is required to be assigned.
Because
because it is just an award and the matter has been carefully considered. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court has also considered view that the Presidential Police Medal for Gallantry, within bracket PPMG, is certainly not a right of one or the other police personnel. The same is an award whereby the gallant of the concern of various police personnel are considered and recognized. And therefore, this court finds that the gallant involved in the present case is dated 5/12/2003, and it has come on record that altogether 13 persons were involved in the said gallant, in which top Naxalite was also killed. In connection with the said incident, names were recommended. Names of 13 persons were recommended, including the petitioners, at the level of the state, at various levels of the state, so that their name could be forwarded to the central government for the purposes of consideration of award, of gallantry award. However, it appears that initially name of only 4 persons were forwarded at the top level of the state of Jharkhand. The counter affidavit does not disclose the reason for not sending the name of all the persons in block. The initial recommendation for 4 persons were declined. However, their case was again recommended along with 1 more person who had expired during the operation, and ultimately 5 persons were conferred the presidential medal. It further appears that the petition number 1 had filed a writ petition before this court, being WPC number, इसमें लिखा हुआ नहीं, ब्लैंक कर दीजिएगा, इसमें मिल जाएगा आपको, WPC number such and such, in which and WPS number 1685 of 2016, ज्योति प्रकाश
ऊपर लिखवाया गया 573
और 57
ऊपर लिखवाया गया मैडम पहले।
अच्छा ठीक, was filed and आपके केस का नंबर लिखा हुआ ना इसमें?
जी।
List of dates का वो number नहीं है. Was filed and a direction was passed by this court for consideration of his case for the presidential medal. Consequently, while his case was being taken up, the name of all the petitioners, including the petition number 1, was ultimately forwarded for consideration of presidential medal. It further appears that the central government called for an explanation
536 of 2013.
536 of
2013.
Ultimately, the Union of India had called for an explanation as to with regard to the delay in making the recommendation, but at the same time called for magisterial inquiry report. And the state government has ultimately sent the magisterial inquiry report with regard to the incident. Thus, it appears from the records of this case that the Union of India has ultimately regretted the medal to the petitioners by order dated, by communication dated 18/2/2016, which is quoted as under. From the perusal of the aforesaid communication, and from the perusal of the materials on record, it appears that the case of the petitioners were considered on merits, though belatedly, and the argument of the petitioner that the case of the petitioner was not considered on account of delay is not correct. In such circumstances, this court finds that the case of the petitioners, the fact also remains that the gallantry award has been conferred on the petitioners by the state of Jharkhand. This court is of the considered view that once the case of the petitioner has been considered and regretted, there is no further scope for issuing any direction upon the respondents. Accordingly, no relief can be granted to the petitioner in this writ petition. Since the case of the petitioners were considered on merit and it has been regretted by Union of India, there is no occasion to grant any compensation to the petitioner with regard to the delay which has taken place from the side of the state for making recommendation of the petitioners.
The Lordship, in the rejection order which has been passed by the Union of India, it has been written that it is regretted and the same is not being approved.
That's right. This is being quoted.
Yes.
And Your Lordship, may I submit one thing, Your Lordship? By Annexure B, the Union of India issue instructions to all the chief secretaries, and in this paragraph 2, it stated that the award of gallantry medal is a continuous process, and the recommendation for the same may be said immediately after the gallant action.
मैडम आपको बात समझ नहीं आई. Delay तो हो गया, but I think he got all the petitioners got advantage of petitioner number 1's order. Otherwise किसी का भी recommend नहीं, consider ही नहीं. Petitioner number 1 में एक writ petition में order हो जाने से ही सबका consider हो गया, otherwise नहीं होगा.
जैसे जब फर्स्ट किया था उसी में सबका दिया था, कहीं पे चला जाना चाहिए, वहाँ से छाटना नहीं चाहिए.
अवार्ड में मैंडेमस करना इतना आसान नहीं है. नहीं, कॉम्पनसेशन वाले एस्पेक्ट पर हम सोचे इसीलिए आज के लिए रखे थे. ऐसा नहीं हुआ कि डिले के कारण आपको रिजेक्ट कर दिया. अगर सिर्फ डिले के कारण रिजेक्ट कर देते ना, तब तो हम आपको कॉम्पनसेशन अवार्ड कर देते. ऐसा नहीं है कि सिर्फ डिले के कारण रिजेक्ट किया. दे हैव कंसिडर्ड इट, वॉट एवर बी द इनपुट्स, वी डू नॉट नो, दे हैव कंसिडर्ड इट. और एक चीज़ और होता है कि गैलेंट जब किसी साल कंसिडर होता है तो उसके साथ और भी गैलेंट कंसिडर होते हैं. तो हो सकता है कि कोई गैलेंट उनको ज़्यादा सूटेबल लगा होगा, बिकॉज देयर इज़ अ लिमिट, द नंबर इज़ लिमिटेड कि किसको कितना दिया जाएगा. आई डू नॉट नो व्हाट इज़ द प्रोसेस. देयर आर सो मेनी थिंग्स व्हिच टेक्स प्लेस.
Now from Delhi College, serial number 31, CRMP 1512 of 2024, Ritesh Kumar.
Yes, petitioner.
Yes.
Where is the petitioner? Petitioner के absence में restoration भी तो हम कैसे allow करेंगे?
There is some issue in the internet.
Some issue in the internet. Display नहीं हो रहा है? हो रहा है? चलिए petitioner absent, next file.
Serial number 32 CRMP 1864 of 2024 Ranjan Kumar Singh.
Yes,
Let's say it is for non-compliance of order dated 8/5/2024 minutes. The case was dismissed for non-compliance minutes. Now my lord says she is ready to surrender.
Cost देना पड़ेगा sir.
She is under treatment, my lord, so that is my cause, my lord, sir. That's why, but nowadays she is ready to surrender at any moment, my lord, as directed by this court, my lord. And the conviction is under 1.5 years.
Cost देना पड़ेगा, बिना cost के नहीं हो सकता. You have taken us for a ride.
By taking into consideration the suspect matter, she being
क्या है थायराइड का प्रॉब्लम क्या है?
नहीं ये अंडर मेडिकल ट्रीटमेंट काफी लंबे समय से चल रही है.
थायराइड का प्रॉब्लम लाइफ लॉन्ग था.
वो तो अभी हम लगाए हैं by taking.
नहीं अभी भी you have to pay some cost. हम रेस्टोर कर देंगे लेकिन बिना कॉस्ट के रेस्टोर नहीं करेंगे. Repeated orders हुआ है for filing surrender certificate. Yes. तो बेकार है हम लोग ऑर्डर ऐसे ही आधा पन्ना का लिख दिए.
Prior to that, my lord, sir, we have also filed an application for injunction for surrender. That
Rejected था ना?
That was rejected, and thereafter, my lord,
उसके
sir,
बाद
वही कह रहे हैं.
You see, a person who is convicted and he does not go to jail. बेकार है पूरा exercise.
That's why we are.
That is why cost.
Ready to.
बिना cost के इसको हम रेस्टोर नहीं कर सकते. Criminal CRMP number 1864 of 2024. Counsel for the parties are present. This petition has been filed for restoration of criminal revision number 309 of 2020, which stood dismissed for non-compliance of order dated 3/5/2024, whereby, by way of last chance, time for surrender certificate, for filing surrender certificate was granted to be filed by 8th of May 2024. On earlier occasions also, time was granted, but the surrender certificate was not filed. The order being peremptory, the case has been dismissed from the court. The counsel for the petitioner submits that the petitioner is an old person and she has been suffering from various ailments and therefore she could not surrender. After hearing the counsel for the petitioner and considering the facts and circumstances of this case, this court finds that the RA seeking exemption from surrender was dismissed as back as on 19th of August 2020. And thereafter repeated time was granted to file surrender certificate. But the petitioner did not care to comply with the orders passed by this court. And ultimately the case has been dismissed on account of non-compliance of order dated 13/5/2024. Considering the submissions, the criminal revision number 309 of 2020 is restored to its original file, and the order dated 3/5/2024 and the time granted by the order dated 3/5/2024 is extended till 13th of September 2024. However, this is subject to payment of cost of ₹5,000 to be deposited before Jharkhand Legal Services Authority. The receipt of deposit is submitted latest by 9th of September. 9th of September. The receipt we filed in this है ना, इसी में आप फाइल
CRMP.
CRMP.
Serial number 33, CRMP 2137/2024, Saurabh Kumar.
This is for restoration of criminal revision filed against 138 conviction and affirmation by order dated 27/6/24, that is annexure 1. We were directed to serve notices by 1st of July. Due to an inadvertence, those notices were not able to be served and therefore it was dismissed. There was a subsequent order for payment of 1 lakh by 29th of July. That payment has been made. That is the entire check amount. Earlier an IA was filed for 10,000. The ladyship was of the view that 10,000 will not be sufficient. And thereafter directions were given to me to check if they can come to some sort of...
This amount has been credited?
Yes, supplementary affidavit has been.
When did you credit this amount? Supplementary affidavit?
In the revision. Annexure 2 of that.
Where is the state? Criminal Division. This is CRMP number 2137 of 2024. Counsel for the petitioner submits that this petition has been filed for restoration of Criminal Division number 29 of 2024, which stood dismissed for non-prosecution on account of non-compliance of order dated 27/6/2024, inasmuch as the notices were not filed within the prescribed period time. It submits that so far as deposit is concerned, the same has already been made. The learned counsel has submitted that the non-compliance with respect to the filing of notice is unintentional and the criminal division be restored. Considering the submissions made, your exemption was allowed.
Yes, on the point of 1 lakh payment.
Considering the submissions made, criminal division number 29 of 2023 is restored to its original file and the preemptive time granted by the order dated 27/6/2024 is extended till next Friday. You have deposited this proof by 31st of July?
By 29th. 26/7. 26 July.
Okay. This petition is accordingly dismissed.
I'm grateful.
Counsel for the parties are present.
Serial number 34 CRMP 2316 of 2024 draft order.
For restoration of criminal division number 682 of 2021, which has been dismissed for non-compliance of order dated 9/9/2021, and dismissed on 14th of March 2024. For this one, the surrender certificate could not be filed on time, also. Therefore, on 14th March 2024, this criminal division was dismissed. There is Annexure 2, order passed by this honorable court. Now, the present status is that Your Worship, the petitioner has been arrested on 29/4/2024 itself, and is in judicial custody since then.
Arrested on?
Sorry? 29/4/24.
Rest of the defects are removed.
The rest of, actually, Your Worship, this has come on NOC, Lordship. I have to check whether the defects, rest of the defects have been removed.
Counsel for the petitioner prays for time to seek instructions and verify the records. Post on next Friday. जेल में रहने दीजिए, पूरा कस्टडी पीरियड खत्म हो जाने दीजिए।
इसमें हमको जहाँ तक एक वर्ष में काइंडली
You do not know, आपका ये जहाँ तक पता है ये सब कहानी आपका रेस्टोरेशन में चलेगा क्या? नेक्स्ट फ्राइडे को भी मत करिए, नेक्स्ट फ्राइडे आराम से इंस्पेक्शन करिए।
नेक्स्ट फ्राइडे कर दीजिए।
You take your time to inspect the records.
I inspected today itself. अभी यहाँ पर आया हुआ होगा फाइल, I just inspect today itself.
Serial number 35 CRMP 2386
नेक्स्ट वीक कर दिया, हम आज के लिए
Next Friday. हाँ? Next Friday.
नेक्स्ट फ्राइडे, ओके।
थोड़ा तो सेंसिटिविटी रहना चाहिए, अगला को जेल भेज दिए।
I was
Why
with
not
the council
time?
worship at that point of time also. After NOC worship, the file has been
दूसरे काउंसिल का जब आप नो ऑब्जेक्शन लेते हैं तो उसका बर्डन भी साथ में लीजिए।
I've taken the burden also.
You have to take the burden. आप लोग का ये भाईचारा नहीं चलने वाला है।
Restoration of criminal division number 1248 of 2023. This application has been dismissed on for non-compliance of order dated 12/7/2024.
रीजन
मतलब एक्चुअली क्लाइंट का नंबर नहीं था तो उसको नहीं बता पाया कि सर्टिफाइड कॉपी लोअर कोर्ट का फाइल करना है, जिसके कारण
जब वो आते हैं तो उनको नहीं बताते हैं।
नहीं तो बाद में कॉल किया हमसे पूछे तो फिर हम
सर्टिफाइड कॉपी अपने पास रख लेते हैं वकील साहब को देने के पहले।
नहीं वो एक्चुअली डिफेक्ट लगा तो फिर हम
डिफेक्ट आपको नहीं पता है, रिविजन में सर्टिफाइड कॉपी साथ में लगाना है।
नहीं लोअर कोर्ट जजमेंट का मतलब
लोअर कोर्ट जजमेंट का भी लगाना
अगेंस्ट एक्विटल है तो अपील का हम लोग लगाए थे सर्टिफाइड कॉपी, लेकिन लोअर कोर्ट जजमेंट का सर्टिफाइड कॉपी नहीं ले पाए थे तो
ठीक
उस चीज़ के लिए।
Are you there for the state? आप हैं इसमें? Counsel for the petitioner submits that this petition has been filed for restoration of criminal division number 1248 of 23, which has been dismissed for non-compliance of order dated 22/6/2024, which has been dismissed for non-compliance of 22/6/2024, as preemptive time was granted to remove the surviving defects. The learned counsel submits that he could not obtain the certified copy and therefore the defects could not be removed. Considering the submissions, the criminal division number 1248 of 23 is restored to its original file, and the time granted for removal of defect by order dated 22/6/2024 in criminal division number 1248 of 2023 is extended till 20th of September. This petition is accordingly disclosed. Time frame पे ही रह गया, extend कर दिए हैं 20 तारीख।
Serial number 36 CRMP 2392 of 2024 सभा आ गई।
Lordship, CRMP has been referred to restoration of criminal division, Lordship, for non-compliance of order. A certified copy apply करना था, Lordship, due to medical emergency में apply नहीं कर पाए।
criminal revision, this CRMP number 2392 of 20. The learned counsel for the petition submits that this petition has been filed for restoration of criminal revision number 1528 of 2023, which has been dismissed for default on account of non-compliance of order dated 22/6/24, whereby preemptive time was granted to remove the defects. She submits that the certified copy could not be obtained on time on account of medical emergency, and therefore the defects could not be removed. After hearing the counsel for the petition and being satisfied with the cause shown, criminal revision number 1428 of 23 is restored to its original file, and the preemptive time granted by order dated 22/6/2024 is extended till 20th of September 2024. This criminal revision, this CRMP is accordingly dismissed.
Serial number 37, the last case, CRMP 2395 of 2024, Mukesh Kumar.
It was dismissed for non-prosecution for non-compliance with the order dated 13/6/2024 passed by this honorable court. There are two defects in this case. First was the certified copy of the trial court judgment was supposed to be filed. And second was the final surrender certificate. It's against the conviction of 138 NI Act. I've stated in my petition that is something against the previous advocate. The certified copy of that judgment was obtained immediately after the scam reporting on 27 January 2023. That was handed over to the previous advocate. I'm still having that in the file. And so the second defect is concerned, there is compromise between the both parties. And there was instruction to the earlier advocate to file IA for compromise and for exemption to surrender. But the petitioner was a student at that time. Well, his father and sister has come. That was not their mistake. The same advocate was handling from the trial court to appellate court, and he also filed this revision petition here. And nobody was appearing in that case. Even on that date, nobody appeared.
Who is the advocate?
But I have stated, I don't want to say some advocate from civil court.
You read paragraph.
Verified. The statement submitted at the present criminal revision number so and so was filed on 25 January 2023 through one Mr. Nikhilesh Kumar Chatterjee advocate. That is stated and submitted as a petition and no knowledge either about any defect in the case or any preemptive order passed by this honorable court. When the memo was issued from the registry of this honorable court, then he came to know about it. Immediately next day he came to me with no objection.
How did he come to know about it?
Look,
How did the petitioner come to know about it?
The same advocate handed over the notice from the registry. I have annexed that copy at page 9, annexure 1 of CRMP.
So if the advocate can hand over the note to the petitioner, it is very much unlikely and unbelievable that
And
he
he
would
disclosed
not inform, the petitioner did not know that he has to surrender.
It was the instruction to the advocate that both parties are compromising. And what is the stage of the proceeding? Even in January 23, the certified copy was handed over.
CRMP number 2395 of 2024. Counsel for the petitioner submits that this revision, this CRMP has been filed for restoration of criminal revision number 96 of 2023. It stood dismissed on 4/7/2024 for non-compliance of order dated 13/6/2024, whereby the preemptory order granted by this court to remove the surviving defects could not be complied. The learned counsel for the petitioner submits that the petitioner had handed over the certified copy of the order of the trial court to the concerned counsel and had also informed him that the parties were on the verge of settling the dispute out of court as the matter was arising out of conviction under section 138 of Negotiable Instruments Act. But the State Council did not take any steps for filing appropriate petition before this court seeking exemption from surrender and joint compromise petition. And consequently, the case stood dismissed on account of non-removal of defects. Considering the aforesaid submission, this court is of the considered view that it is for the litigant to contact his counsel from time to time with regard to the progress of the matter and putting blame to the counsel, to the earlier conducting counsel is not completely justified. However, considering the interest of justice, Criminal Revision number 96 of 2023 is restored to its original file, and the preemptory order granted by the order dated 13/6/2024 is extended till 20th of September 2024, subject to payment of cost of ₹5,000 to be deposited by the petitioner in Jharkhand Jharkhand High Court Legal Services Committee. The receipt of the same be filed before this court by 9th of September. It is further observed that it will be open to the petitioner to file appropriate petitions in the Criminal Revision number 96 of 2023 and mention the case even prior to 20th of September. यही आ
Yes.
अदर साइड को पकड़ के लेके आइए.
हाँ आ जाएगा वो कॉम्प्रोमाइज है.
That's all.